battle is brewing between Apple and the federal government in a showdown pitting privacy rights against national security concerns. The Justice Department filing a motion Friday to compel the company to follow through on a federal judge's orders. The FBI wants Apple to crack the phone belonging to San Bernardino terrorist Saeed Farook, but Apple argues it would threaten the privacy of every iPhone owner. PayPal co-founder Max Levchin telling Maria Bartiromo there is no guarantee that door can be closed once it is open.
Do you think if Apple were to just open up this one phone, that would create a backdoor for others to have access to our information?
If they hand the can opener, so to say, to the FBI, yes. If they don't, presumably they can destroy the software the second they use it once, but the precedent will have been set.
All right, let's talk about it now, bringing in Robert Schalk and David Schwartz, both defense attorneys and former prosecutors. All right, good to see both of you.
Hello.
And David, I'm going to start with you because not only is Apple asking, the government asking Apple, the feds, they want them to not just crack the phone, but they want them to come up with new technology to get into the phone. Is this a fair or unfair request?
I mean, first of all, Apple has complied with all of these court orders. You know, they have handed over everything that's within their records. They have handed over. Now the court is ordering them to create new technology to crack open this phone, and it's completely out of bounds. We've never seen anything like it ever in a court order, and it completely goes over the line. You can't order a private company to create new technology to crack open a phone.
So you're talking about Apple having complied, not just with this case, but they've said they've complied with like some 70 cases already.
Yes.
All right, how do you see it, Robert?
Well, I agree with David. However, there's one case that if I'm the government, I hang my hat on this case. In the 1970s, the court ordered that phone companies agree to help create pen registers. And pen registers are used every single day on search warrants all over this country. That is where the government can get a search warrant to look at your phone and it records your call log. So there is some precedent where courts have ordered companies and the government to work together to create this type of technology. And if I'm arguing the case on behalf of the government, that's the case I rely on.
I agree with you, but the technology existed. That's the difference. Here today, the technology doesn't exist.
Right, that's the problem.
Now, okay, Robert, so Apple and Apple executive is saying to the company, pardon me, saying that the company, what Apple would prefer to do is to let Congress set rules for when the tech companies have to cooperate with the government rather than the court doing this on a case-by-case basis.
There's a case in the Eastern District of New York on Long Island where a judge agrees with that assessment from Apple. They said that there's the 1994, it was the Communications in Support of Law Enforcement Act where they told telecommunications companies to support law enforcement. However, it hasn't been amended to include cell phone companies, data like this. So they're saying, why don't you have Congress pass the law and we won't have these arguments, we won't have these issues any longer.
I totally agree. Congress has to, although Congress is so dysfunctional, when's the last time they passed any law? So, you know, but absolutely they have to amend the law to include this situation.
So, David, Apple is saying that this is a fight to protect civil liberties. Is that a strong argument?
Well, it is a strong argument because there's definitely a privacy right at hand here, but I'm not sure that's the winning argument. I think the winning argument really is you're trying to force us to do something that we don't have. We don't have the technology. Why don't, Mr. Government, why don't you come up with the technology to crack the phone, and then you'll have to deal with the courts, and it'll be out of our hands. How do we do that to our customers that now we have to create a new technology to crack our own phone?
And Apple says that not only do they not have this technology, that it would be too dangerous to create it.
Right, dangerous and burdensome. The law that the government's relying on is from the 18th century. That's how old the law is that they're relying on here. And one of the defenses for Apple is going to be, this is too overly burdensome on us. You're requiring us to spend our money and our efforts to create technology that doesn't exist. And that's been David's point the entire time.
And why doesn't the government hire Apple? Maybe they should just outright hire Apple because they can't do it themselves.
Right.
Don't let the court force them to do it.
There you go. Listen, so by the way, Apple has until Friday, Feb 26th, this Friday, to respond to the judge's orders. And then there's a court hearing set for March 22nd for the judge to hear both sides. So I know you will be keeping a close eye on this.
Absolutely.
And we'll have you both back.
Great.
Robert Schalk and David Schwartz. Good to see both of you.
Thank you, Arthur.
Absolutely. Hey, Eric, your turn.